counts 1 to 8 against you.
Yes, I do understand, my lord.
Is it necessary for the state to read out those counts to you?
It's not necessary, my lord.
And what do you plead to them?
Not guilty.
Thank you.
Thank you, my lord. The are also the alternatives with relations to count 1 to 8. Alternative 1, that being theft leveled against the accused.
Do you understand the first alternative to counts 1 to 8?
Yes, I do, my lord.
What do you plead that thereto?
Not guilty.
Thank you.
Alternative 2 of counts 1 to 8, that being of attempted theft, are also leveled against the accused.
Do you understand the second alternative to counts 1 to 8 as well?
Yes, I do, my lord.
And what do you plead?
Not guilty.
Thank you.
The third alternative to count 1 to 8, being contravention of section 34 of Act 12 of 2004, failure to report a corrupt transaction, is also leveled against this accused.
You also understand the third alternative to counts 1 to 8?
Yes, I do.
And you plead?
Not guilty.
Thank you.
And then finally, my lord, counts 21 up until 28, the counts of money laundering, are also leveled against the accused.
Do you understand the contents of counts 21 to count 28? That is the counts of money laundering.
Yes, I do, my lord.
What do you plead to those counts?
Not guilty.
Mr. Skuman?
Thank you, my lord. Confirm that the pleas of not guilty on all the charges is according to my instructions. My instructions is further that the state is put to prove all these allegations contained in these charges. The accused reporting pleads in particular that further the state has not complied with Section 27 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, PRECA, as read with Section 34 thereof. As you please.
Thank you, Mr. Skuman. Accused number 15, Mr. Makepe. Thank you, Ms. McPherson.
Thank you, my lord. The accused is also facing charges of counts 1 to 8, that being fraud. It may be inquired whether the state needs to formally put the charges to the accused.
Mr. Makepe, are you acquainted with the contents of counts 1 to 8 against you, the counts of fraud?
Yes, I am.
Is it necessary for the state to read out those counts to you?
Not necessary.
Thank you. What do you plead to counts 1 to 8?
I plead not guilty.
Thank you.
Thank you, my lord. The first alternatives of counts 1 to 8 is also applicable to this accused, namely theft.
You understand the alternative to counts 1 to 8, namely the counts of theft?
Yes, I do, my lord.
And what do you plead thereto?
I still plead not guilty.
Thank you.
Thank you, my lord. The second set of alternatives of counts 1 to 8, that of attempted theft, is also levelled against this accused.
the alternative count of attempted theft pertaining to counts 1 to 8. Do you understand that count?
Yes, I do, my lord.
And you plead?
I plead not guilty.
The third alternatives with regards to counts 1 to 8, namely contravention of Section 34, Act 12 of 2004, being the failure to report a corrupt transaction, is also leveled against the accused.
Do you understand the third alternative of corrupt activities?
Yes, I do, my lord.
That is now in relation to counts 1 to 8. What do you plead to the third alternative?
I plead not guilty.
Thank you.
And the accused is further charged with counts 21 up until 28, the counts relating to money laundering.
Do you understand counts 21 to count 28 relating to money laundering?
Yes, I do, my lord.
And you plead?
I plead not guilty.
Thank you.
Those are all the charges leveled against this accused.
Thank you, Mr. Skuman.
Thank you, my lord. I confirm that the pleas of not guilty to these charges is according to my instructions. The accused put the state to prove these allegations contained in these charges. The accused pleads in particular that the state has not complied with Section 27 of Act 12 of 2004 PRECA as amended with Section 34 thereof. As you please, Mr.
Thank you, Mrs. Skuman. We now come to accused number 16, Mr. Albertus Venter. Thank you, Mr. Venter.
My Lord, I'm aware of what is contained in counts 1 to 8, as well as the three alternatives, and I understand same. I'm also aware what is contained in counts 21 to 28, and I understand as well what is contained in those charges. My plea on counts 1 to 8, as well as the three alternatives, as well as 21 to 28, is a plea of not guilty.
Thank you. Mr. van Schalkwyk.
Thank you, Lord. I confirm my clearance. Firstly, again, I confirm that the pleas are in accordance with my instructions. Lord, we've prepared a very brief Section 115 statement. Ours differs a little from the rest of it in that there have been requests for particulars in terms of Section 87 of the Act, and the state has duly replied to those. So my Lord will see in what I'm about to read out that I refer to those. And I will in due course establish from the Lord's registrar whether the Lord has a full set of those pleadings as it amends the final indictment as well. May I proceed in reading to the record, Lord?
Yes, just give me a
I
moment.
need to hand up a signed original from the Lord to follow. You've listed the charges as well. I've handed out as many copies as we have and handed to the state. May I proceed?
Thank you, Mr. van
Thank you,
Schalkwyk.
Statement from Section
Will you
115.
just give me a moment, please? Sorry to interrupt you. Thank you. You may proceed,
Thank
sir.
you, Lord. I, the undersigned, Albertus Venter, state as follows. I am accused number 16 in the above matter before this honourable court. 2, I have received copies of all the indictments in this matter, in particular of the final indictment, dated and signed on 10 August 2023, amending counts 21 to 80, and the applicable annexures pertaining to these counts. I have studied all of the indictments and understand the contents thereof. I've also read the request for particulars, the request for information, filed on my behalf, and the state's replies thereto. Insofar as the replies to the request for particulars amplify the indictment, I understand the agreements therein. I plead not guilty to the charges I'm arraigned on, namely, and then 4.1 and 4.2 it's listed. Counts 1 to 8, fraud, and the first and second and third alternative counts thereto. Counts 21 to 28, money laundering and contravention of Section 4A and or B of Act 121/1998. 5. I have been informed of the provisions of Section 51 in brackets 2 of Act 105/1990, which should read 7, my apologies, and the schedules thereto, pertaining to minimum sentences, which the state alleges apply to counts 1 to 8 and the alternative charges thereto. Lord, I beg leave to effect an amendment. I'll have the accused sign the date of the act accordingly. In amplification of my plea of not guilty, I state further as follows. 6.1, I deny all the elements of the offences I am charged with the state to the proof thereof. I plead in particular that insofar as it concerns the charge against me in the third alternative count to counts 1 to 8, the Director of Public Prosecution's Free State did not comply with the provisions of Section 27C of Act 12 of 2004, the Prevention and Combating of Corrupt Activities Act 12 of 2004, in that she did not provide me with a reasonable opportunity to offer an explanation, as envisaged by Section 27C, prior to authorizing my prosecution on an alleged contravention of Section 34(1)(a) or B, read with Section 34(2) of Act 12 of 2004, dated today and signed by the accused on page 3 of the statement. That is the Section 115 statement.
Thank you, Mr. van Skalkwyk. You confirm, Mr. Venter?
I do.
Thank you very much. You may be seated. Thank you. The statement of accused number 16 is accepted as Exhibit 4.
As it pleases the Lord.
Accused number 17, Ms. Charlotta. Thank you. You are represented by Advocate Macapella. Thank you. Advocate Macapella. Where is that? Yes. I understood you to say earlier that we may proceed by putting the charges to the accused.
Indeed, my lord.
Thank you very much. You may proceed, Ms. McPherson.
Thank you, my lord. The accused, before I formally put the charges, my lord, the court will note that the accused is charged with counts 21 to 28, as well as counts 67 to 71 relating to money laundering. And in terms of the extradition, those were the charges that the state had not been granted the go-ahead on, and therefore those charges are withdrawn before I put the rest of the charges for which the accused is to be faced.
Yes, so certain charges are withdrawn, so we will only work on the counts, the charges that you are about to put to accused number 17.
Indeed, sir.
Thank you. You may
A quick word, if I may. Could I seek clarity from the state why the charge sheet has not been amended in terms of Section 43 to record the withdrawal of the charges that they are indicating that they withdrew?
Yes, do
It's not necessary.
My colleague full well knows on what basis the client was extradited from America. She knows full well that we could not, according to the extradition order in the United States, pursue these charges. So why must I now type a new indictment? We just stand up and withdraw the charges. So I can't understand the problem.
Regrettably, my Lord, Advocate Nation is, the state is referring or answering a question that I had not asked. The indictment indicates the counts 1 to 8 as well as the counts 21 to 28 and 67 to 71. This was in terms of an amended arraignment that was applied for at the Magistrates Court in terms of Section 43. My question is, knowing the state knew that these charges would be withdrawn or that extradition was not granted in terms of these charges as early as August last year, and an amendment was not applied for in terms of Section 43 at the Magistrates Court as is required by the CPA. And so I'm referring to the procedural act, because as we currently have it, it states here that the magistrate of the Bloemfontein High Court, or the magistrate in Bloemfontein, amended the charge sheet in terms of Section 43. The question that we are asking is, if these charges 21 to 71 were withdrawn, why was the charge sheet not amended? Why was an application not made to the Magistrates Court for an amendment of the charge sheet?
This is the first time in my career that I've heard that we have to apply to a magistrate to amend a charge sheet or indictment. There's no such thing.
Yes, Ms. Makopela.
No, this is what I'm referencing. This is the charge sheet. The charge sheet states here that application is hereby made for the amendment and issue of a warrant for the arrest of Nomalanga Muradi Selina Choloda on the charges of, and it states they count 1 to 8 fraud, count 15 to 19 corruption, count 21 to 28 money laundering, count 67 to 71 money laundering, and it is then signed and stamped 11 August 2023, which means an application was made to a magistrate for the amendment of this charge sheet, and this is what it was. However, upon withdrawing the charges, a further application ought to have been made reflecting the charges and the counts that she is charged with, not skipping, as they intend to do now, the charges that are still reflected in the warrant of arrest.
Yes, Ms. Makopela, I hear what you say.
Thank you.
But in the end, we have to work with realities. And now we are here in court, and now all the accused in this matter are pleading to the charges, and the state has now informed the court that they are withdrawing certain charges against the accused, and that is it. I cannot make an order that they must still proceed with those charges against the accused. I cannot really see the sense of going into the history of this matter, of what happened in the Magistrates Court, and therefore my ruling is simply that the charges that are left against accused number 17 may now be put to her so that she can plead to it. Thank you. You may proceed, Ms. Pearson.
The accused is, as indicated by my colleague, charged with counts 1 to 8 of fraud. I'm not sure whether it be necessary that I formally read the charges onto record, or if we can also agree to the same.
Ms. Charlotta, are you acquainted with charges 1 to 8 of the indictment against you?
May I request them to be read?
Yes, by all means. Please read them out to the accused. Start with count number 1.
As please. In that during the period 2014 to 2015 and at or near Bloemfontein, in the district of Bloemfontein, the accused, individually or collectively, acting in the furtherance of a common purpose with their co-accused and or persons unknown to the state and or representatives acting on their behalf, unlawfully, falsely, and with the intent to defraud, explicitly or tacitly, through words or conduct, and or failed to act pertained to the Department of Human Settlements and or the Treasury Department and or the state that the contract between the Department of Human Settlements, Free State, and accused 3, 4, and 5, and subcontracts between accused 3, 4, and 5, and accused 7, 8, 9, and 10 were legitimate contracts in terms of the policies, procedures, prescripts, and legislation as outlined in the preamble, and or the contract between the Department of Human Settlements, Gauteng, and accused 3, 4, and 5, on which the Free State contract was based, and which made it possible to implement the same concept in the Free State, was a legitimate contract in terms of the policies, procedures, prescripts, and legislation as outlined in the preamble, and all proper procurement processes as prescribed by legislation, guidelines, and policies as outlined in the preamble were followed in awarding the contract to accused 3, 4, and 5 in Gauteng and or the Free State, and or accused 1, 2, 11, 12, 13, and 18, and all persons directly or indirectly associated with them had no personal or financial interest in the awarding of the contract to accused 3, 4, and 5, and or accused 7, 8, 9, and 10, and all monies paid over and received by to accused 3, 4, and 5, and all accused 7, 8, 9, and 10 were legally due and not the subject or result of any unlawful practices, and all the work that formed the basis of the contracts was completed and or done properly and cost effective, and or the department received value for money, and or accused 3, 4, and 5 was entitled to and could legally subcontract with accused 7 and 8 without disclosing such fact to the department, and or accused 7 and 8 was entitled to and could legally subcontract to accused 9 and 10 without disclosing such fact to the department, and or to accused 3, 4, and 5, and or accused 7, 8, 9, and 10 were entitled and or allowed by law to conduct the work in respect of asbestos stipulated in the contracts, and or no prices and or fees were inflated, and or no stipulations of the contract were altered, whereas the accused, when they made such misrepresentations, individually or collectively, and or together with representatives and or unknown individuals acting on their behalf, knew that the contract between the Department of Human Settlements, Free State, and accused 3, 4, and 5, and subcontracts between accused 3, 4, and 5, and or accused 7, 8, 9, and 10 were illegal and irregular, and or the contract between the Department of Human Settlements, Gauteng, and accused 3, 4, and 5 was illegal and irregular, and or the contract between Human Settlements, Gauteng, and accused 3, 4, and 5 could not be used as a basis for the implementation of the same contract and or concept in the Free State, and or proper procurement processes as outlined in the preamble were not followed and adhered to, and or accused 1, 2, 11, 12, 13, and 18 had personal or financial interest in the awarding of the contracts in Gauteng and the Free State, and or the payment of 230 million to accused 3, 4, and 5, and subsequent payments by accused 3, 4, and 5 to accused 7 and 8, and by accused 7 and 8 to accused 9 and 10 were not legally due and or were the result of unlawful practices, and or the work was not done properly and or completed and was not cost effective, and or accused 3, 4, and 5, and or accused 7, 8, 9, and 10 were not entitled and or allowed by law to conduct the work as stipulated in the contracts, and or accused 1 and or 2 and or 11 were not entitled and or allowed to appoint accused 3, 4, and 5, and accused 3, 4, and 5 not entitled and or allowed to subcontract accused 7 and 8, and or accused 7 and 8 to subcontract accused 9 and 10, and or had to disclose such facts to the department, and or the contract price was inflated from 650 Rand per house to 850 Rand per house, and or discrepancies existed regarding the services to be rendered in terms of the contract. The unsolicited proposal and the letter of appointment created the impression that the appointment was for the assessment, removal of asbestos material, and the replacement of asbestos roofs. The service level agreement only referred to assessment and removal. The instruction to perform work was only issued for the assessment, whereas the contract price remained the same. And through the aforementioned misrepresentations and or omissions, the accused individually and or collectively persuaded the Department of Human Settlements and or the Treasury Department and or the state to its actual or potential prejudice to award the contract as outlined in the preamble and to pay an amount of 230 million rand on the dates stated in the preamble of a total contract amount of 255 million rand to the accused as outlined in the preamble.
Do you understand counts 1 to 8 relating to fraud, Ms. Charlotta?
Yes, my lord.
And what do you plead that thereto?
I plead that the court has no jurisdiction to try this case, therefore I plead not guilty.
You are pleading not guilty in the first place. Not guilty, and you also say that this court has no jurisdiction to hear the matter.
Correct.
Thank you.
Thank you, my lord. The accused is also charged with the first alternative to count 1 to 8, that being theft. If I may proceed to read the charges onto record.
Please do so.
In that, at the time and place mentioned in the main count, the accused unlawfully and intentionally stole 230 million rand property of the state.
Do you understand the first alternative to counts 1 to 8, Ms. Charlotta?
Yes, my lord.
And you plead?
I plead that the court has no jurisdiction to try this offense. I therefore plead not guilty.
Thank you.
Thank you, my lord. The accused is also charged with the second alternatives of count 1 to 8, that being attempted theft. In that at the time and place mentioned in the main count, the accused unlawfully and intentionally attempted to steal 25 million rand property of the state.
You understand that alternative charge, Ms. Charlotta?
Yes, ma'am.
And you plead the same as the previous occasions?
Correct, not guilty.
Thank you, my lord. If we may then turn to page 46 of the indictment, count 15, corruption, contravention of section 3 of Act 12 of 2004. If I may proceed to read into record.
That is count 15.
Count 15, 1-5, indeed, so my lord.
Yes, you may proceed reading it out.
Thank you, my lord. That the accused are guilty of the crime of corruption in contravention of section 3A, Roman numeral 2, and or Roman numeral 3, and or Roman numeral 4, read with sections 1, 2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that on or during August 2015 at Bloemfontein, in the district of Bloemfontein, the accused directly or indirectly and wrongfully and corruptly accepted and or agreed and or offered to accept any gratification, namely payment of 53,550 rand paid on his request towards the tuition fees of the daughter of Phil Mkwena, which was not legally due, from Ignatius Mkambani and or accused 5, in order to act and or omit to act personally and or by influencing another person to act in a manner that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules, and or which was designed to achieve an unjustified result, and or that amounted to any other unauthorized or improper inducement to do or not to do anything. In that the accused had knowledge of the irregular and or illegal nature of the agreement between accused 3, 4, and 5 and or Ignatius Mbani and the Department of Human Settlements and or accused 1, and unlawfully and intentionally condoned the irregular and or illegal nature of the said agreement and illegally requested Ignatius Mbani and or accused 5 to pay the said amount on behalf of Refilwe Mokoena.
Do you understand count 15 against you, Ms. Charlotta?
Yes, Madam.
And you plead?
I say not guilty.
And
That the court has no jurisdiction.
yes, thank you. I'm recording it as such.
Thank you.
Thank you.
Thank you, my lord. The accused is also charged with the first alternative count to count 15, namely corruption, being the contravention of section 4 of Act 12 of 2004, if I may proceed to read it onto record.
Yes, you may.
That the accused are guilty of the crime of corruption in contravention of section 4(1)(a), Roman numeral 1, and or Roman numeral 2, and or Roman numeral 3, read with sections 1, 2, 42, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in the main count, accused 13, who was employed as a premier and as such a public officer and a member of the executive of the Free State, and accused 17, who was employed as his personal assistant, directly or indirectly and wrongfully and corruptly accepted and or agreed and or offered to accept a gratification from Ignatius Mbani and or accused 5, whether for the benefit of himself or for the benefit of another person, namely the payment of 53,550 rand on behalf of Refilwe Mokoena towards the tuition fees of her daughter, in order to act personally or by influencing another person so to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out or performance of any powers, duties or functions arising out of a constitutional, statutory, contractual or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules, designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything. In that the accused had knowledge of the irregular and or illegal nature of the agreement between accused 3, 4, and 5 and or Ignatius Mbani and the Department of Human Settlements and or accused 1, and unlawfully and intentionally condoned the irregular and or illegal nature of the said agreement and illegally requested Ignatius Mbani and or accused 5 to pay the said amount on behalf of Refilwe Mokoena.
Do you understand the first alternative to count 15, Ms. Charlotta?
Yes, I do.
And you plead?
Confidently plead not guilty.
Thank you.
Thank you, my lord. If we may then turn to page 49 of the indictment, count 16, corruption, contravention of section 3 of Act 12 of 2004, if I may proceed with the charges.
Yes.
That the accused are guilty of the crime of corruption in contravention of section 3A, Roman numeral 2, and or Roman numeral 3, and or Roman numeral 4. Read with sections 1, 2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that on or during June 2015, at Bloemfontein, in the district of Bloemfontein, the accused directly or indirectly and wrongfully and corruptly accepted and or agreed and or offered to accept any gratification, namely the payment of 470,000 rand, paid on his request to MTAG Systems for the acquisition of 200 electronic tablets, which was not legally due from Ignatius Mpumbani and or accused 5 in order to act and or omit to act personally and or by influencing another person to act in a manner that amounts to the abuse of position of authority and or a breach of trust and or the violation of a legal duty or a set of rules and or which was designed to achieve an unjustified result and or that amounted to any other unauthorized or improper inducement to do or not to do anything. In that the accused had knowledge of the irregular and or illegal nature of the agreement between accused 3, 4 and 5 and or Ignatius Mpumbani and the Department of Human Settlements and or accused 1 and unlawfully and intentionally condoned the irregular and or illegal nature of the said agreement and illegally requested Ignatius Mpumbani to pay the said amount to MTAG assistance.
Do you understand count 16, that is a count of corruption, Ms. Charlotta?
Yes, I do, my lord.
And you plead what?
Not guilty.
Thank you.
I also stress the point that the court has no jurisdiction
Yes,
to try those cases.
yes.
Thank you.
My Lord, the accused is also charged with the first alternative count, count 16, corruption in contravention of Section 4 of Act 12 of 2004. If I may proceed to read this.
Yes, you may.
That the accused are guilty of the crime of corruption in contravention of Section 4(1)(a), Roman numeral 1 and or Roman numeral 2 and or Roman numeral 3, regular sections 1, 2, 42, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in the main count, accused 13, who was employed as a premier and as such a public officer and a member of the executive of the Free State, and accused 17, who was employed as his personal assistant, directly or indirectly and wrongfully and corruptly accepted and or agreed and or offered to accept a gratification from Ignatius Mpumbani and or accused 5, whether for the benefit of himself or for the benefit of another person, namely payment of 470,000 rand to MTAG Systems for the acquisition of 200 electronic tablets in order to act personally or by influencing another person so to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete, or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything. In that the accused had knowledge of the irregular and or illegal nature of the agreement between accused 3, 4, and 5 and or Ignatius Mpumbani and the Department of Human Settlements and or accused 1, and unlawfully and intentionally condoned the irregular and or illegal nature of the said agreement and illegally requested Ignatius Mpumbani and or accused 5 to pay the said amount to MTAG Assistance.
Do you understand the first alternative to count 16?
Yes, my lord.
Thank you. And you plead?
Not guilty.
Thank you.
Thank you, my Lord. If you may then turn to page 52 of the indictment relating to count 17, corruption in contravention of Section 3 of Act 12 of 2004. Leave with the court, if I may put the same in report.
Thank you.
That the accused are guilty of the crime of corruption in contravention of Section 3A, Roman numeral 2, and or Roman numeral 3, and or Roman numeral 4. Radio sections 1, 2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. and that on or during the period 31 August 2015 and 1 September 2015 at Bloemfontein, in the district of Bloemfontein, the accused directly or indirectly and wrongfully and corruptly accepted and or agreed and or offered to accept any gratification, namely the payments of 200,000 and 100,000 rand respectively, paid on his request to Griffin Edge Pty Limited for the acquisition of 200 electronic tablets, which was not legally due from Ignatius Mpumbani and or accused 5, in order to act and or omit to act personally and or by influencing another person to act in a manner that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules, and or which was designed to achieve an unjustified result, and or that amounted to any other unauthorized or improper inducement to do or not to do anything. In that the accused had knowledge of the irregular and or illegal nature of the agreement between accused 3, 4, and 5, and or Ignatius Mpumbani and the Department of the Human Settlements, and or accused 1, and unlawfully and intentionally condoned the irregular and or illegal nature of the said agreement and illegally requested Ignatius Mpumbani and or accused 5 to pay the said amounts to Griffin Edge Pty Limited.
Do you understand count 17 against you?
Yes, I do, my Lord.
Thank you. And what do you plead?
I plead that the court has no jurisdiction to try the offense. Therefore, I plead not guilty.
Thank you.
Thank you, my Lord. The accused is also charged with the first alternative count to count 17, corruption in terms of contravention of Section 4 of Act 12 of 2004. With leave, if I may read the same into record.
You may.
That the accused are guilty of the crime of corruption in contravention of Section 4(1)(a), Roman numeral 1, and or Roman numeral 2, and or Roman numeral 3. Regular sections 1, 2, 42, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in the main count, accused 13, who was employed as the Premier and as such a public officer and a member of the Executive of the Free State, and accused 17, who was employed as his personal assistant, directly or indirectly and wrongfully and corruptly accepted and or agreed and or offered to accept gratification from Ignatius Mpumbani and or accused 5, whether for the benefit of himself or for the benefit of another person, namely payments of 200,000 rand and 100,000 rand to Griffin Edge for the acquisition of 200 electronic tablets in order to act personally or by influencing another person so to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete, or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out, or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation. That amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or set of rules, designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything. In that the accused had knowledge of the irregular and or illegal nature of the agreement between accused 3, 4, and 5 and or Ignatius Mpumbani and the Department of Human Settlements and or accused 1, and unlawfully and intentionally condoned the irregular and or illegal nature of the said agreement and illegally requested Ignatius Mpumbani and or accused 5 to pay the said amounts to Griffin Edge Pty Limited.
Do you understand the first alternative to count 16, Ms. Charlotta?
Yes, ma'am.
Can I accept and assume that you plead not guilty because it is an alternative charge? You plead not guilty and you still maintain that this court has no jurisdiction.
Correct, my Lord.
Thank you.
Thank you, my Lord. If you turn to page 56 of the indictment, namely count 18, corruption in terms of contravention of Section 3 of Act 12 of 2004. If I may place same on record.
It is now count 18.
18, 1-8.
Yes, thank you.
That the accused is guilty of the crime of corruption in contravention of Section 3A, Roman numeral 2, and or Roman numeral 3, and or Roman numeral 4. Read of Sections 1, 2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. And that on or during June 2015 at Bloemfontein, in the district of Bloemfontein, the accused directly or indirectly and wrongfully and corruptly accepted and or agreed and or offered to accept any gratification, namely the payment of 30,000 rand paid on his request to SWC, my apologies, Mkati, which was not legally due from Ignatius Mpumbani and or accused 5, in order to act and or omit to act personally and or by influencing another person to act in a manner that amounts to the abuse of position of authority and or a breach of trust and or the violation of a legal duty or a set of rules, and or which was designed to achieve an unjustified result and or that amounted to any other unauthorized or improper inducement to do or not to do anything. In that the accused had knowledge of the irregular and or illegal nature of the agreement between accused 3, 4, and 5 and or Ignatius Mpumbani and the Department of Human Settlements and or accused 1, and unlawfully and intentionally condoned the irregular and or illegal nature of the said agreement and illegally requested Ignatius Mpumbani and or accused 5 to pay the said amount to SWC Nkati.
Do you understand count 18 against you, Ms. Charlotta?
Yes, my lord.
And you plead?
Not guilty, my lord. And the same with the jurisdiction.
Yes, I've recorded it as such.
Sorry.
Thank you, my lord. The accused is also facing charges of the first alternative count 18, corruption in contravention of Section 4 of Act 12 of 2004. With leave of the court, if I may read the same as the record.
You may.
That the accused are guilty of the crime of corruption in contravention of Section 4(1)(a), Roman numeral 1, and all Roman numeral 2, and all Roman numeral 3. Read with Sections 1, 2, 42, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in the main count, accused 13, who was employed as a premier and as such a public officer and a member of the executive of the Free State, and accused 17, who was employed as his personal assistant, directly or indirectly and wrongfully and corruptly, accepted and or agreed and or offered to accept gratification from Ignatius Mpumbani and or accused 5, whether for the benefit of himself or for the benefit of another person, namely payment of the amount of 30,000 rand to SWC Nkati, in order to act personally or by influencing another person so to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete, or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out, or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules, designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything. In that the accused had knowledge of the irregular and or illegal nature of the agreement between accused 3, 4, and 5, and or Ignatius Mpumbani and the Department of Human Settlements, and or accused 1, and unlawfully and intentionally condoned the irregular and or illegal nature of the said agreement, and illegally requested Ignatius Mpumbani and or accused 5 to pay the said amount to SWC Nkati.
Do you understand the first alternative to count 18, Ms. Charlotta?
Yes, ma'am.
And you plead?
Not guilty in the same with regards to the
Thank you.
My Lord, then if we may finally turn to page 59 of the indictment relating to count 1919, corruption, contravention of section 3 of Act 12 of 2004. With leave of the court, if I may put this to the accused.
Yes, please.
That the accused are guilty of the crime of corruption, contravention of section 3A, Roman numeral 2, and or Roman numeral 3, and or Roman numeral 4. Regular sections 1, 2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the period November 2015 and January 2016 at Bloemfontein in the district of Bloemfontein, the accused directly or indirectly and wrongfully and corruptly accepted and or agreed and or offered to accept any gratification, namely the payment of 250,000 rand paid on his request to Astra Travel towards travel expenses of a delegation to Cuba, which was not legally due, from Ignatius Mpambani and or accused 5, in order to act and or omit to act personally and or by influencing another person to act in a manner that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules, and or which was designed to achieve an unjustified result and or that amounted to any other unauthorized or improper inducement to do or not to do anything. And that the accused had knowledge of the irregular and or illegal nature of the agreement between accused 3, 4, and 5, and or Ignatius Mpambani and the Department of Human Settlements and or accused 1, and unlawfully and intentionally condoned the illegal and or irregular, my apologies, and or illegal nature of the said agreement and illegally requested Ignatius Mpambani and or accused 5 to pay the said amount to Astra Travel.
Do you understand count 19 against you?
Yes, my lord.
And what do you plead?
Not guilty.
And also the jurisdictional aspect.
Indeed.
Thank you, my lord. Then the final count against the accused is with regards to the first alternative count, count 19, corruption in contravention of section 4 of Act 12 of 2004. With leave, if I may put the same to the accused.
Yes, you may.
That the accused are guilty of the crime of corruption in contravention of section 4(1)(a), Roman numeral 1, and or Roman numeral 2, and or Roman numeral 3, regular sections 1, 2, 42, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in the main count, accused 13, who was employed as a premier and as such a public officer and a member of the executive of the Free State, and accused 17, who was employed as his personal assistant, directly or indirectly and wrongfully and corruptly accepted and or agreed and or offered to accept a gratification from Ignatius Mpambani and or accused 5, whether for the benefit of himself or for the benefit of another person, namely payment of 250,000 rand to Astra Travel towards travel expenses for a delegation to Cuba in order to act personally or by influencing another person so to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete, or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out, or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything. In that the accused had knowledge of the irregular and or illegal nature of the agreement between accused 3, 4, and 5 and or Ignatius Mpambani and the Department of Human Settlements and or accused 1, and unlawfully and intentionally condoned the irregular and or illegal nature of the said agreement and illegally requested Ignatius Mpambani and or accused 5 to pay the said amount to Astra Travel.
Do you understand the alternative count to count 19? Thank you, Ms. Lotta. And what do you plead thereto?
I plead that the court has no jurisdiction to try this offense. And therefore I plead not guilty.
Thank you. Ms. Macapella, you may be seated. Thank you.
Thank you, my lord. My lord, I confirm that the pleas are in accordance with the instructions that I have received from case number 17. My lord, we prepared a notice which we handed to the state that we were to file a plea explanation in due course. If I may please hand up the document that was served on the state yesterday.
Yes, please. Thank you. Yes, thank you. I take note of it.
As it pleases the court. My lord, could I receive direction then, because we are faced with a bit of a problem. Our printed version of the plea explanation is on its way from the correspondent attorneys. Unfortunately, because we're based in Johannesburg, we have to liaise with our attorneys and then the correspondent attorneys. However, I do have my own handwritten version of it, which I may read into the record for time purposes. Or we could endeavor to have the printed version that will be signed by Ms. Chilota read into the record, as whichever the court directs us to.
Yes, when do you expect the printed version to arrive?
I understand that the partner of the correspondent attorneys is currently in the regional court and he's on his way to his office to retrieve it for us, or rather to make the copies for us.
Here in Bloemfontein? Here in Bloemfontein?
Here in Bloemfontein.
Could it perhaps happen over lunchtime?
It could.
Because we are fast approaching lunchtime.
Indeed, no, it could not.
Yes. Is it necessary for me to enter this notice that you've handed up and give it a number? I don't think it's...
It's not necessary, my lord. It was simply to record that we gave the state reasonable notice of what we intend to do with the plea explanation.
Yes, can I hand this notice then back to you?
My lord, and then just quite apart from the plea, could we receive direction with regard to the request that we made yesterday regarding our client's bail conditions? Will that be dealt with at the end of these proceedings?
Yes, we will deal with it after the pleas have been brought to finality. I think for the moment you may read out. You say you have a handwritten version of the plea explanation. You may proceed to read that into the record, and then after lunchtime you can then hand in the typed version thereof.
Plea explanation in terms of section 115 of the CPA, read with section 108 of the CPA. The accused, number 17, Ms. Nomalanga Murwadi Cholota, pleads not guilty in terms of section 106 1F of the Criminal Procedure Act, that this court does not have jurisdiction to try the offenses that she is charged with. In amplification of the accused's plea in terms of section 106 1F, the accused avers that her extradition was unlawful. The state is put to the proof that the accused is guilty of the charges against her. The state is further put to the proof that the extradition of the accused was lawful. In further amplification of the above, and in terms of Section 108 of the Criminal Procedure Act, the following issues are raised. 1. The state lied, alternatively misrepresented, to U.S. authorities that there was reasonable and probable cause for the charges against Ms. Cholota. Subsection 1. She was charged after she would not implicate Mr. Makashule, accused number 13, in a witness interview by the state's investigators on 21 and 22 September 2021. 1.2. The state itself informed the Constitutional Court in a sworn affidavit deposed to by one of the investigators, Captain Khalid, that, I quote, the fact that Ms. Cholota did not attribute certain instructions to her former boss had the result that she was then treated as a suspect in relation to some of the same charges Mr. Makashule, her former boss, was facing. Full stop. Paragraph 133 of the third respondent's affidavit submitted to the Constitutional Court. 1.3. The charges against the accused was simply a follow-through of the threat the investigators had made against her that she would be charged if she did not cooperate with them. The state does not deny the threats or that they were made. They simply allege the threats were fair warning. The evidence will show that there was never a reasonable and probable cause for the charges and that U.S. authorities were lied to or misrepresented to. 2. The state lied or misrepresented to U.S. authorities that the accused number 17, Ms. Cholota, was a fugitive from justice. 2.1. The basis for the request of the extradition, which is the surrender of a fugitive from justice, was that accused number 17 refused to or was not returning to the country to face trial. This information was proved to be false during the bail proceedings. 2.2. The magistrate De Lange found that there was no evidence that the accused had been contacted by the state and informed of a hearing date. 2.3. The magistrate also found that there was no evidence that the accused had been anywhere other than her university attending classes at all times. 2.4. The accused had demonstrated previously that she obeyed court or legal summons when she had traveled back from the United States to South Africa to give testimony at the Zondo Commission in December 2019. This was also confirmed by the magistrate in her judgment. 2.5. The state lied to or misrepresented to U.S. authorities that the accused was refusing to come back to the country and thus a fugitive. And
yes, now, if the court has to accept that Mr. Mslangu now has everything at his disposal,
Yes.
can we place him in a position where he has to deal with the evidence of state witnesses either today or tomorrow at such short notice?
I think so. The witness that I intend to call, the first one, is from Johannesburg. He is here. So I would like to call him tomorrow morning. But I've also heard from some of the council that they would like to, they haven't approached the court yet, but they would like to leave earlier because they have to drive inter alia to Durban.
I won't recommend it. Have you seen the weather in Durban, Mr.
I haven't, but that's why one of the reasons why I don't go there. Because they don't want to get stuck on the N3 and so forth.
Yes, there's another issue. Tomorrow morning, unfortunately, I have a pre-trial that I have to attend to at 9:30. Tomorrow morning, I don't know how long it's going to take. But say, for instance, it takes up time until 10:30 or 11. then we sit with the situation that it's almost Easter weekend. Everybody wants to get away, as you say, to Durban. And
or else your lordship was just prohibited to leave on a lighter note. But yes, I can just tell the court I shall never finish that witness, say from 11 to 1. Never. It's a lot of evidence. So
yes,
if there's so many problems, I'll instruct the gentleman to come again on Tuesday.
yes. I'm really sorry, Mr. Nason. I wouldn't have taken on this plea trial, but it was assigned to me before I was made aware of the fact that I was the lucky winner of this particular trial. So if I had known that beforehand, I wouldn't have taken on the plea trial. But now I'm sitting with the plea trial and with this one. That is why I'm committed to do the pre-trial tomorrow morning 9:30, and its counsel attorneys coming from Welkom, that's not too far, but in any event it has been arranged some time ago.
What we would like to do, my lord, is, at least for this afternoon, there's an opening address which outlines, broader than the indictment, the whole state's case. So we would like to place that on record.
Yes, I take note of it, but in any event, there's a request from one of the accused that the bail, I think it's accused 17, that the bail conditions be relaxed. I don't know what the state's approach is to that request, but I would like to deal with that issue before the Easter weekend. In other words, this afternoon. But it shouldn't take long, I think. But before we come to that, Mr. Mhlanga, I must say again, I'm so glad to see you here.
Thank you, my lord. My lord, unfortunately, the status quo hasn't changed. I do not have a docket in front of me. And even if I were to have one right now, I do not have adequate time to prepare for this trial, my lord. I've only been briefed and I made my first appearance on the 11th of April, my lord. Everyone here, my legal colleagues, has been here no less than 3 months to prepare for today's proceedings.
Yes, I can understand that you want some sort of a postponement to prepare yourself for this trial. The question is, how long will that request for a postponement be?
My lord, right now we're in the middle of April. It will take nothing less than 2 months to prepare for this matter.
How long?
Nothing less than 2 months from today.
2 months?
Yes, my lord, because we are dealing with an issue of a terabyte of information which runs to more than 50,000 pages, my lord.
Yes, Mr. Slangu, let me say to you so that there can be no misunderstanding. I'm not likely to postpone this matter to any date beyond next Tuesday. And then the state's case must proceed. It must commence and it must proceed. There have been so many delays in this matter over long periods of time that we cannot proceed in such a fashion. This trial must continue and it must be disposed of. And I want to say to you that, in my view, if you are given time until Tuesday morning to look at the papers as far as you can, to consult with your client and be here on Tuesday, then as the witnesses are called and as they testify, And when you have a need to consult with your witness before you cross-examine each respective witness, I promise you that I will lean over backwards and I will give you ample time to consult with your client pertaining to the evidence of any particular witness before you cross-examine that witness. But I cannot allow, unfortunately, I cannot allow a situation where all these accused and all their legal representatives are held at ransom for a month or two only because one of the accused and one of the legal representatives say to the court that they are not ready to proceed. That is my preliminary view. Next week, Tuesday.
My Lord, with respect, my Lord, as I said earlier, my Lord, everybody here who's representing a accused had nothing less than 3 months to prepare for today's proceedings. And secondly, I do not even have a docket in front of me as we speak, my Lord.
Mr. The Nation say you will have the docket shortly, and it is Wednesday today. I'm affording you almost a week to do whatever is necessary to start with this trial. There is no need to read 20,000 or 30,000 pages in order to prepare yourself. There is no need for that, certainly.
My Lord, how do I or my client prepare when we don't even know which documents to look into in respect of each one? Yes, because we do not know how the arrangement of the docket looks like, and in respect of if we are to proceed on Tuesday, how sure are we that we are prepared to even start to do these proceedings? Because we just do not know how far this docket goes.
Yes, but I've told you now, Mr. Mslango, that I will give you ample opportunity to consult with your witness and to look at papers if you feel the need to do so after a witness has testified, so that you can appraise yourself of what the state's case is pertaining to that specific witness, and so that you could be able to cross-examine him. Thank you. You may be seated for the moment, Mr. Nason. You say there is a reasonable possibility that the docket would be in Mr. Mslango's possession this afternoon still.
My Lord, he has it. He has it on a hard drive. His computer just doesn't want to read that hard drive. We took the hard drive that he received last week on Friday, we put it into one of our computers, and we could see everything. So,
but you said his attorney has got the appropriate computer to read that hard drive.
So he said. He says.
The attorney.
Yeah. So there shouldn't be any problem in reading. It's not a question of the hard drive cannot open. He's just got the wrong operating system on his computer.
No, you've got the wrong operating system.
My Lord, ours work.
According to your own version.
No, it works on all our computers.
Who is the attorney of Mr. Mslango?
My Lord, it's Mohano in
Yes. Is he present here in court? Thank you. Is it correct what Mr. The Nation says?
I haven't attempted to open the disc, but will attempt to do so in the afternoon when we leave the court today.
Thank you. You will do your best to try and open it.
Yes, we will try our level best. I'll request my IT people to assist you.
Please, I appreciate your efforts. Thank you. Then, anything else that you want to say in this respect, Mr. Mslango?
My Lord, it will be skating on thin ice to deliver on the same point, my lord, because it literally puts the accused at a prejudiced position that you just have to literally be preparing for trial whilst trial is running at the same time.
Yes, I take note of what you say.
And that literally goes to the core of the issue of fairness of trial in terms of the constitution of the Republic.
Yes. Now, on this point, Mr. Denison, Mr. Mslanga says that even if he gets the hard drive open in the course of this afternoon, he says it's far too less time to prepare and be ready for the evidence and the further proceedings by Tuesday. What is your view?
If Mr. Mslango sleeps very little or does not sleep, he would be able to go through everything, I think. But I agree with your lordship. There's no need to read each and every piece of paper. There's thousands of, for instance, bank statements that he doesn't need to read. There's a whole forensic audit, as I said, that sums up this whole case. If he at least reads that, he will know how everything fits together. So it can be done.
And that audit is on your hard drive.
Yes. It is.
You look a bit uncertain.
Yes, no, it is there, but it's his hard drive. We just copied it. But I'm even prepared to favor him with a hard copy of that report. Not the annexures, it's too many. But I'll give him the report.
When?
This afternoon, when we walk out of here. So that he can at least start with that while they struggling with their computer issues. I can't do better than that.
Fine. Can I then, for the moment, move on to the bail issue of accused number 17?
Yes. Will the court just bear with me 1 second? I just want to talk to my investigating officer.
Yes.
Not a consultation, just an instruction. Thank you, my lord. As I understand it, the request is that the appointments, the visiting of the police stations, reporting
on Mondays and Fridays.
Yes, we'll concede to that. But we still want a condition that the accused contact the investigating officer when she leaves the Free State, just to tell him where she is going. But the reporting can be scrapped.
Where is Advocate Pacapella?
Thank you, my lord. My lord, could I please first start by apologizing for walking in late in your court?
No, it's my fault. I'm apologizing. I came in early.
Thank you, my lord. Thank you, my lord. My lord, when we first made the request for the relaxation of the bail conditions, one of our first things that we stated was that none of the fellow co-accused have any conditions attached to their bail, and that this this strikes to the root of equality in law. And there's no reason for her to be reporting to the investigating officer for any reason other than the fact that the state wishes to still maintain that control over her. But there's no actual reason, practical reason that would serve. And so we would categorically like to state that we wish for Ms. Chilota to have the exact same bail conditions that the other co-accused in this matter have. And so for the state to think it's justifiable to impose conditions on one accused that they would not even think of imposing on another is completely unjustifiable.
What conditions are there in relation to the other accused? That they must attend the trial or what?
That they must attend the trial, my lord. But there's nothing about that. If they leave the Free State province, they must call the investigating officer, or that they're confined to any specific area. It is simply just Ms. Chilota. And may I mention, my lord, as you saw this afternoon, how difficult it is for us to liaise between the corresponding attorneys and us. It is as difficult to consult with her, because either the attorney has to travel to Bloemfontein or schedule a virtual call and work around our schedules. And so it's practically, it serves no purpose. But the only purpose that it serves is to further punish Ms. Chilota unjustifiably by the state for no reason whatsoever. So we wish for her to have the exact same bail conditions.
Thank you. Mr. Nason, you've heard what he said.
Yes, I find it quite amazing. The big difference between her client and accused 17 and the others, not one of the others had to be extradited from a foreign country. We went through a whole bail application, and it's not as simple as what my colleague stated in the plea explanation. That's only half of the story. So we are bending backwards to accommodate this accused by letting go of the reporting. But what is the problem with just picking up a phone, listen, I want to leave the Free State, I want to go to Cape Town or wherever, this is where I'm going. How can that be a problem? Yes, he must be to some extent be treated differently than the other accused. The other accused, some of them, they were called and they presented themselves, not accused 17. We struggled for 2 years to get her out of the United States.
Yes, Mr. De Nason, Ms. Makapala, I want to deal with this issue of the bail conditions of accused number 17 as quickly as possible. But I cannot expect the rest of this courtroom, all the legal representatives, all the accused, to sit here and to listen to this show going on between you and Mr. De Nason.
It's a singular show.
Pardon, sir?
It's a singular show. It's a one-sided show. Certainly no show from our part. Certainly no show from our part. It's a singular show.
Yes, that was just a way of expressing myself. I didn't mean it to have any legal meaning. But what I am saying is that I'm now, Mr. De Nason, I'm now going to postpone this this matter to Tuesday morning, 9:30. And okay. I'm going to postpone it to Tuesday, and since there seems to be conflict between the state and the legal representation of accused number 17, I will entertain the issue of bail either this afternoon as you wish or tomorrow morning.
It's a question of,
and I will excuse the rest of the audience.
as it pleases the court, it's a question of your lordship making a ruling. We've conceded to the bigger part of the application. It's a very simple condition that remains. In my view, there's nothing more to be said. It's a question of your lordship makes a ruling that it stands or it doesn't stand. I can't take it further than that.
My Lord, prior to the postponement, now be heard on the practical proposal, if I may.
Yes, thank you, Mr. Otis.
My Lord, I made it clear that we're ready to proceed, but as a practical proposal, what I had in mind to propose to your Lordship that would assist my learned friend for accused number 2, and I believe all of us as well, so we do benefit from it, my Lord, would be that if there are two legs to it. Firstly, if we were supplied with a list of witnesses in advance, then it would focus his reading and ours as well, because as your Lordship has heard how vast the docket is. So then we'd be in a position, if we know some order, even if it's just the next 2 or 3 witnesses, then we can prepare in advance and he can scale down his preparation. So I think just as a list, we've been told to the first witnesses that are friends to mother and friends, if we're told to the first, second and third, etc. So we know in advance, then it would be much quicker to prepare. And then the second, and it's just a proposal because I've heard your Lordship and I don't want to be standing a row of your Lordship's ruling, is if one has a look at the calendar, my Lord, and if one were to postpone to the following Tuesday, just as a suggestion, your Lordship knows that Monday is a holiday and the following week the Monday is also a holiday. So then by four court days, you give my learned friend an extra almost 10 or 12 days to prepare, which I think would be a practical proposal. That instead of postponing to the Tuesday the 22nd of April, or a practical proposal in my submission would be to make it Tuesday the 29th of April, which would then be a ruling that we run from there without stopping. It's just a proposal, my Lord.
Thank you, Mr. Otis.
My Lord, may I just also make a submission to your Lordship?
Yes, Mr.
My Lord,
Kasim.
my opening address won't take longer than 30 minutes. On Tuesday, my Lord, unfortunately, my learned junior and I are involved in a foot bench appeal in this court, which was before your Lordship, you may recall. And then the Deputy Judge President was conflicted. And then it was enrolled for, just 2 months ago, it was enrolled for this Tuesday. So I have that difficulty. And I also have this other issue, my Lord, that I don't want to sit here and take the taxpayers' money. If I do the opening address, the understanding is then I come back when I'm required to deal with special pleas, my Lord. So I would ask your Lordship for the indulgence that I can deliver the opening address. I promise not to take more than 30 minutes. I have a written document. And then I'm excused until my team needs me.
It is in this afternoon, your opening address.
Yes, my Lord.
Yes.
Thank you.
Mr. Donation, are you prepared to provide the respective counsel who are interested in the first names of the first 3 witnesses?
I am prepared.
Will you do you undertake to do so when we adjourn here now? Thank you. Mr. Kasim, you say that on Tuesday morning you are involved in a full bench appeal.
In this court, yes.
And one can never really say how long it's going to take, isn't it?
Well, probably done in the morning, my Lord. I think by 2 o'clock I'll be in a position.
Yes, but should I expect all the other
No, my Lord.
legal representatives to be here by 9:30 on Tuesday and then sit and wait?
No, my Lord.
And I must add that on Tuesday morning, first thing in the morning, 9:30, I have to entertain an application for leave to appeal in another matter. So that is also something that has to be done before we can proceed further with this matter.
My Lord, is it not possible that I can do that this afternoon? I see it's 20 to 3. I'll be done by the latest 3:30, my Lord, not beyond that.
You're referring now to the opening address? Yes, now I'll give you the opportunity to do that.
Yes.
But I first want to get rid of all the other issues.
I'm not required here as far as the first witness is concerned. In fact, I've indicated to my little friend, Mr. Hodis, who our first witness is.
Yes, thank you, Mr. Kasim. Mr. Hodis, I've taken note of what you've said. And you referred to the 4 days next week. Don't you think, in view of the fact that there are other hurdles on Tuesday, that at least we could use Wednesday, Thursday and Friday next week?
Yes, it's not my, it's an inherited request. I think it should be coming from accused number 2. But I do believe that would assist if it was.
Yeah. Yeah.
Yes, Your Lordship, please.
Thank you. Yes, I will make the appropriate order later this afternoon, but I have to say that I intend to stand down these proceedings until Wednesday, 23 April at 9:30 in the morning, to proceed on the 23rd then, the 24th and the 25th. That will at least grant Mr. Mslanga a further day to get these things in order, and I do so having regard to the undertaking by Mr. Denason of providing counsel with a list of the first 3 witnesses to testify in this matter. As far as the bail issue of accused number 17 is concerned, there is now a conflict between the state and accused number 17. As far as that is concerned, I will deal with that issue tomorrow at 11 o'clock. And the rest of legal representatives and accused are all excused. They are excused from attending court on Tuesday. Sorry, they are excused from attending court tomorrow. Tomorrow is Thursday. We won't proceed tomorrow with this matter. And they are also excused from attending court on Tuesday the 22nd. That is the day after the Easter weekend. The case will proceed on Tuesday the 23rd at 9. Wednesday at 9:30 in the morning. So all Ms. Makapela Capella, are you open and are you willing to be in court tomorrow for the bail issue?
My Lord, I asked my attorney to quickly confer with client as to whether her instructions still remain regarding the other the jurisdiction point, and she's indicated that she concedes and that if the reporting is relaxed, then she is fine to report to the state should she leave the Free State.
Thank you. Thank you, Ms. Macapella. It seems to me that settles the matter of the bail.
It seems so.
One fact. Yesterday the court authorized the warrant for accused number 5 for number 6 and held it over until 9:30. Today we presented the medical report and we confirmed that the accused is going to be available when we come to court on Wednesday next week. In that regard, I then request the court either cancel the warrant or to hold it over until Wednesday, the 23rd, when we come to court.
Lord, may I ask that the warrant be kept in abeyance until Wednesday? Not to cancel it, because if she does not appear on Wednesday, then we start.
Yes, thank you, Mr. Rambau. The warrant of arrest that was issued yesterday is then held over further. It is extended until Wednesday, 23 April 2025.
Thank you, my Lord.
Thank you, sir. You say that accused number 5, accused
The representative of the company, Michelle,
no.
He's accused 6. The representative of accused 6. So 605.
Yes, that is the lady that is in hospital.
Yeah,
isn't it?
clinic. A so-called clinic.
Yes.
Michelle Mbambani. Yes.
Okay. Yes, but her warrant of arrest is now held over until Wednesday. But now I'm coming back to the bail issue.
Apparently it's now been resolved.
Yes, I just want to make sure. Yes, the bail issue refers to accused number 17.
That is correct.
Yes. And you have heard Ms. Macapella saying that she is willing, the accused number 17 is willing to report to the investigating officer if she wants to leave the Free State province.
Correct.
Thank you. Could the investigating officer be so kind to provide her with his telephone number?
They have everything, but yes, we'll do it again.
Thank you. Yes, then I make the following order as far as accused number 17 is concerned. The conditions of bail for accused number 17 are amended to the effect that she no longer has to report to the police station on Mondays and Fridays, but she has to report to the investigating officer if she needs to leave the Free State province. Do you understand that, accused?
Can I just consult with my Yes, I do understand.
Thank you. Are there any other issues that we have to address?
One last time, my lord.
Yeah.
If I could beg leave to hand up the exhibit.
Oh yes, oh yes, that is Exhibit 5 as I
Exhibit
indicated
5,
before. Yes, thank you. Thank you, Mr. Kasim.
Just one last, very last aspect, housekeeping. I've spoken to some of my colleagues. We understand that the microphones from the media is kept on if the court adjourns, and that picks up conversations between prosecutors and counsel and their clients and so forth, which is not for the public domain. So we request an order that the microphones be switched off the moment the court adjourns. Thank you.
Thank you. The media must please see to that all the microphones are switched off every time the court adjourns until the time that the court resumes again. Please.
Thank you.
Yes. Mr. Kasim,
Yeah.
you wanted to proceed with your opening
Thank you, my
address.
lord. Half an hour is undertaken. I have a written copy for the court and for my learned friends.
Thank you.
Thank you.
I accept this copy as Exhibit 6.
As a purposes. My lord, it's not a comprehensive document. In other words, it doesn't cover each and every count, particularly I don't deal with the alternative counts, but the state is not abandoning any of the charges as formulated and as set out and as pleaded to. My lord, in introduction, I simply point out to your lordship, this involves Free State Department of Human Settlements. The period is 2014 to 2016. A number of government officials, I'll just expand on that very briefly, shortly, engaged on what the state believes is a clear-cut fraud. It involves private persons. Then, my lord, in the factual metrics, your lordship will see in paragraph 4, it deals with the asbestos eradication project. And in paragraph 5, we identify the department here of the first accused, Mr. Mokesi, received an unsolicited proposal from Black Cat Consulting, Diamond Hill Trading, a joint venture, to perform an appointment on risk audit and assessment handling of hazardous material removal and disposal of asbestos contaminated rubble in the Free State province. There are 2 points I want to make here, my lord, which I think are very important for this trial. Firstly, my lord, our law knows no notion of an unsolicited bid. An unsolicited bid, my lord, has to be treated in terms of procurement law. In other words, you start off 2171 of our Constitution, my lord, where an organ of state wants to procure goods or services. It does so in a manner which is transparent, fair, competitive, and cost-effective. That's the safeguard. The ultimate safeguard, my lord, is Section 2171 of the Constitution. And your lordship knows that the legislation to give effect to that is the PFMA Act, and then there are Treasury regulations and change management policy. That's the first point. The second point I want to make, and I think it's important, my lord, because it's dealt with by the first witness on behalf of the state. Your lordship will see that the bid is for inspection, removal, and replacement of those asbestos roofs, which herald prior to 1994 and which poses a risk to the health of people. But ultimately, the contract itself, the service level agreement, is simply for inspection and removal. What's dropped, my lord, is the replacement of the roof. That's the first point I want to make. The second point I want to make, my lord, on this particular aspect is this, my lord. In terms of the regulatory framework, as far as the treatment of asbestos is concerned, and this will be expounded by the first witness, you have an initial stage of an inspection. For that, you need a competent person. And then when you are removing, my lord, that competent person must be certified in terms of a training program, in terms of Occupational Hazards Act. And when he's actually removing, my lord, he should do so in the presence of an inspectorate from the Department of Health. All that is absent here, my lord. Then, my lord, I move on to point out to your lordship in paragraph 7. What was employed here, my lord, there was no competitive bidding, which is really the cornerstone of procurement law. Because what's very important, my lord, from the state's point of view, is you want value. And how do you determine you want value? You go to a competitive bid. So what they did here, my lord, they piggybanked onto a contract that was given in Gauteng, an asbestos eradication project in Gauteng. Now that is permissible, my lord, under 16A66, but your lordship will hear that the stringent requirements of 16A66 were not met. It wasn't the same party. One of the parties to the joint venture had that contract. Price and delivery was not the same. And more fundamentally, by the time this contract started, that contract had already ended. So you could not piggyback on a contract which otherwise would be permissible if the requirements were met. And then, my lord, in the heart of the matter, your lordship will see that this was a contract, and I set it out, my lord, more fully in paragraphs 8 to 11. And in 11, my lord, I referred to A, B, and C. And perhaps that really illustrates why, on the state's version, this was a thief's picnic. And I want to take your lordship to A, B, and C. Because the numbers reveal what happened here. So, my lord, I demonstrate to your lordship in those paragraphs what is common cause, my lord. This is a contract given for 255 million. Half, my lord, is paid up front. Ultimately, 230 million is paid. But the joint venture, which is the beneficiary of this contract, subcontracts it, my lord, to the 8th accused. Just to give a name, my lord, so it rings a bell because your lordship heard plea explanations. That goes, my lord, to a company called Master Trade. And my lord, I'm giving you approximate figures here. Contract value is 255 million. 230 is paid to the joint venture. Joint venture, my lord, subcontracts it to Master Trade for 44 million. Effectively, that's 20% of value. Master Trade then, my lord, subcontracts it to Ori Group. That's accused number 10 for give or take 23 million. The evidence will be that they were in fact only paid 6.3 million. In fact, they sued for the balance of the money. The illustration, my lord, of the numbers, my lord, is set out in A, B, and C. I ask your lordship to be kind enough to turn to A, B, and C. And next just A, B, and C, my lord. Wrong file, sorry, thank you. Your lordship will see from A, my lord, the evidence would be, and this is flow of funds. But this is not, it's flow of funds. It's documents procured from the banks in terms of section 205, which is prima facie evidence. It's black and white. Your lordship will see that 230 million flows from the Free State Department of Human Settlement. From the joint venture bank account, my lord, your lordship will see 102.9 million goes to 605 Consulting. And your lordship has come across 605 Consulting, which is accused number 6, represented by Michelle and Anshia Panbani. She, my lord, is the wife of the now deceased sole director of Diamond Hill Trade. And she's the lady, my lord, who then your lordship will see 102.9 million goes to 605 Consulting. Your lordship will see 36 million go to Master Trade. Your lordship will recall I said the day with the subcontractors to do the work, and the contract was in the vicinity of 45 million rands, and they then, my lord, they then contracted with Ori Group for some 23 million, paid Ori Group 6.3 million. And your lordship will see the split of the income in the next year A, and that's going to be, my lord, from my understanding from my learned friend, but he'll confirm it, the third witness will take some time explaining this. When your lordship goes to annexure B, your lordship will see a breakdown of how Master Trade's bank account dealt with the 36 million rands that it received from human settlements. your lordship will see 12.6 million went to the MTD trust. Then your lordship will see 8 million to properties, 6.8 million to vehicles, 12.5 million to Mr. Radebe himself, 99,000, just under 100,000, my lord, was spent on the computer program that did the work. So when you're looking at value, my lord, your lordship will see 100,000 rand is what the software and the hardware cost. And if your lordship turns to next to see, it's more frightening, because your lordship will see, when you look at Ori Group, my lord, your lordship knows they now had a contract for 23 million, they got paid 6.3 million, but only your lordship will see 1.9 million is used for salaries. Your lordship will see business expenses 957,000. So the picture, my lord, from the accounting point of view, my lord, is that the value received by this great province of yours, my lord, was very little, my lord, minuscule in terms of what was paid. Of course, my lord, if I go back to a next year, my lord, your lordship will know now that the real beneficiary, from the point of view of 605 Consulting, my lord, 112.9 million was Mr. Mapambani's trust, my lord, and his family. And your lordship will recall that the person who now stands responsible to answer for this, my lord, said to your lordship this morning that she is otherwise indisposed. I don't believe it was a medical note that was given to your lordship. I understand it was a note from Bio Vigao Clinic. I haven't seen it, my lord, but that's what I heard. Bio Vigao Clinic. I googled it. It says their speciality is our IV drips infusions are designed to enhance your body energy, detox, and dehydration. My lord, this particular accused who doesn't come to court, doesn't tell her attorney why she's not in court. Your lordship will report, only mentioned it at lunchtime, she's not here. He didn't know where she is. There's no real evidence before your lordship. In fact, my lord, the hearsay evidence is remote, because he couldn't even tell your lordship which clinic she is. But when I looked at this, my lord, they specialize, my lord, in vitamins that boost energy. Basically, they deal with treatments of obesity, my lord. They charge 1,550 rand for 2 hours. That's what they advertise. And then my learned friend and officer of the court said to your lordship, the doctors are not prepared to tell your lordship what's wrong with her. And she knew there's 18 other accused here, my lord, and she wasn't here. And I would implore your lordship, my lord, to take a hard line on her, simply for the dignity of this court, my lord, and for accountability. I then go back, my lord, to my opening address. I've really covered, my lord, paragraphs 11 onwards. And then, my lord, in paragraph 13, we demonstrate where payments were made, my lord. And these payments, my lord, again, my lord, they're prima facie evidence, because they extracted from bank accounts of the very accused who are before your lordship. I can read it out, my lord. Sum of 650,000 paid to Kramer, Wellman Joubert attorneys as a deposit for the purchase of a property by Likomo Trust linked to Mr. Mokesi, who's accused number 1. I will shortly deal with the roles of an accounting officer in terms of the PFMA Act. 1 million, my lord, on the 26th of May to SMB Trading Group with the notation Mr. Zulu being accused 11, sum of 30,000 to SRC President 1 Nakati, and 470,000 for MTX Systems. The sum of 53,500 for student fees for the child of 1 Mukwena on 13th August 2015. She, my lord, your lordship may recall, That's the child of Mrs. Mokwena, who during that period, my lord, I can't give your lordship the exact date, but she acted as a judge in this court. The sum of 200,000 and 100,000 paid to Griffin Edge, sum of 250 to Extra Travel, sum of 10 million to accused 13 between November 2014 and March 2015, sum of 10 million to accused 11 between November 2014 and March 2015, and the sum of 5 million to accused number 1 over the period November 2014 and March 2015, in the sum of 1 million to accused 12 over the period November 2014 and March 2014, in the sum of 1 million to accused 18 over the period November 2014 to March 2015. Numbers don't lie. Your lordship will see how the payments are made when the third witness gives evidence. These payments were, for the most part, made shortly after the JV had received the payment tranche from the department purportedly in connection with the asbestos project. So, my lord, if I may just try and sum up, my lord, insofar as what I've said to your lordship up to this stage, my lord, our law knows of no unsolicited bids concept. You have to invoke procurement law. Your lordship will know, my lord, lots of money flowed to the JV. Little, if any, value was received. Then, my lord, and it's very vital, my lord, that I point out a paragraph from the well-known all-pay judgment. I've cited it in paragraph 20 of my heads, where From and J, sitting in the Constitutional Court, unanimously wrote, as Corruption Watch explained with reference to international authority and experience, deviations from fair process may themselves all too often be symptoms of corruption or malfeasance in the process. In other words, an unfair process may betoken a deliberately skewed process. Hence, insistence on compliance with process formalities has a threefold purpose. It ensures fairness to participants in the vote process. There was no fairness here. Unsolicited bid. They get the bid. They say we're going to go inspect roofs. We're going to remove it and replace it. The SLA says you inspect and remove, period. It enhances the likelihood of efficiency and optimality in the outcome, and it serves as a guardian against process skewed by corrupt influences. My lord, when your lordship hear evidence from bank documents, how various of the accused people got monies, the thought must go to your lordship's head, and I appreciate the right to remain silent. I appreciate that you don't have to give a version on the criminal law, but the thought must go. If it's an innocent payment, why is that not, particularly from a public official and particularly from successful business entrepreneur, why is an explanation law put up? But your lordship will deal with that in the fullness of time. And then, my lord, I ask your lordship, there's a significant commentary, my lord, because I deal with Treasury Regulation 1686, simply to put it down, to make it easy for everybody to say these are the requirements, were they met or not. I must then ask your lordship just to turn to paragraph 26, where I deal with the charges. Now there, your lordship, I'm not going to try and deal further with fraud, because your lordship has more experience, far more insight, and of course greater wisdom than I will ever have as far as fraud is concerned. But your lordship will see the misrepresentation is glaring in this case. What you are doing goes through the whole process of the Free State government so that the payment can be made. The misrepresentation that I'm doing a necessary task in the public interest, when that necessary task did not comply at all, my lord, with procurement law. The misrepresentation is there. This is not a case about potential prejudice. It's actual prejudice. 230 million wasted, could be used to fix up the potholes, could be used to bring clean water and constant supply of electricity to the people of this city, my lord. That's the fraud, my lord. Then when your lordship will look at PRECA, your lordship will see That, my lord, we've given the definitions in this long heads, my lord, simply to make it easy for anybody, my lord, easy point of reference. But your lordship will see that under pressure, it's really the measures the legislation has taken to prevent corruption. And your lordship will see that it's observed by doing nothing instead of being proactive. When it comes, my lord, to the failure to comply with Public Finance Management Act 1 of 1999, there are 3 points I want to make, my lord. The first is this, my lord. In terms of Section 36 of the PFMA, every department must have an accounting officer. Under Section 38, my lord, that accounting officer is required to take proactive steps, my lord, to avoid wastage. And then, my lord, under Section 39 and 40 of the PFMA Act, there are reporting functions. And my lord, what is very important in this case is Section 86. Section 86 creates an offense, my lord, not only when there's intention, my lord, but when there's gross negligence on the part of an accounting officer in not complying with Section 38. The sentence prescribed, my lord, is a maximum of 5 years and fines. So your accounting officer, my lord, is the ultimate responsible party to avoid breaches of procurement law. Accused number 2, my lord, who I'm now told, my lord, is the director of your procurement processes. He is the custodian of your supply chain management policy. I've already pointed out to your lordship his inefficiency, my lord, in procuring counsel, but I don't want to go there. But I want to say this to your lordship. Under Section 45 of the Act, if he is remiss in his duties, which on the common cause facts he is, my lord, then there must be consequent management. I just want to point that out to your lordship. Then, my lord, there are contraventions of the asbestos regulations, which your lordship will hear evidence about. And then, of course, there's the money laundering charges. And when it comes to the money laundering charges, if I may ask your lordship to turn to paragraph 77 of my written submissions, of our written submissions, your lordship will see money laundering is said to take place in 3 stages: placement, layering, and integration. Placement, my lord, placing in the bank, frequently by splitting up the sum into small amounts, which can be then deposited into different bank accounts without raising suspicion. Layering is separating the funds from the illegal source so that the source is disguised to movement and the blurring of the trade. Integration is where the illegitimate funds then laundered are placed under the control of the criminal. And I'll ask your lordship then, just again, to have a glance at the next year, A, B, and C. If your lordship goes to A, your lordship will see how the 230 million is split up. I've already pointed out 112.9 million to 605 Consulting, 36 million went to Master Trade, Mr. Khadebe's company, 17.9 million to Diamond Hill Trading, which is an accused before your lordship, Mr. Mabani's company, the late Mr. Mabani. His wife is having some treatment while we are in court. And then 62.6 million went to Black Hat Consulting. And then your lordship will see how Master Trade dealt with the money in the next year. B, I've already taken your lordship through that. The actual device to do the work, 99,700,000 rands, just short of 3,000 rand, short of 100,000 rand. That's the actual software to do the work from a 255 million rand contract. And then to do the actual work, the lordship will see 957 is used for business expenses, 1.9 million for salaries. So, my lord, what we've identified in this document, no point taking your lordship paragraph by paragraph, is going to be the subject matter of evidence. But what we have done, my lord, is to give statutory definitions so that when evidence is laid, it's a nice quick check, my lord. But there is a matter which I want to just point out to your lordship, and that your lordship will find in paragraph 95. Because much of this case, my lord, on the state's case, my lord, of grand thievery, my lord, is based on common purpose. And my lord, common purpose is applicable, we say in paragraph 95, where two or more people agree to commit a crime or actively associate in a joint unlawful enterprise. In such an instance, each will be responsible for specific criminal conduct committed by one of the number which falls within their common design. The purpose of the doctrine is crime control. The prosecution is relieved of the burden in consequence crimes of proving causality on the part of each person acting in the group. And my lord, the Constitutional Court in footnote 7 in Tevis and another versus S, citing Sleiman, my lord, the doctrine of common purpose is a set of rules of the common law that regulates the attribution of criminal liability to a person who undertakes jointly with another person or persons the commission of a crime. Burchell and Milton define the doctrine of common purpose in the following terms: where two or more people agree to commit a crime or actively associate in a joint unlawful enterprise, each will be responsible for specific criminal conduct committed by one of the number which falls within their common design. Liability arises from their common purpose to commit the crime. Sleiman points out that the essence of the doctrine is that if two or more people having a common purpose to commit a crime act together in order to achieve that purpose, the conduct of each of them in the execution of that purpose is imputed to their others. So, my lord, with great respect, to demystify this particular case, my lord, is during a period, 2014, 2016, in this province, in this city, my lord, an unsolicited bid, contrary to Section 217, contrary to PFMA Act, contrary to Treasury regulations, contrary to chain management policy, my lord, ends up in a contract of 255 million, which by now 230 million has been paid. Which value, my lord, if the real test is what value was given, my lord, ultimately somebody was paid 6.3 million to do the work. It is so that he has a contract for 23 million, but he was paid 6.3 million from the 230 million. The rest of the money, my lord, was distributed between businessmen, powerful politicians, and high-ranking officials. That's what this case is about, my lord. In pure, crude terms, brazen theft, my lord, which is now couched as fraud, alternatively theft, contravention of PFMA Act by the two accounting officers, number 1 and number 18, and in between that, a number of other officials who participated because they received a reward in one way or another, who were in a position in terms of the Salabi judgment and the Sheikh judgment to exert influence for this particular operation to reach conclusions. Then, of course, my lord, is the flow of funds, which, my lord, amplifies the charges of corruption and of course, my lord, of money laundering. That, my lord, in a nutshell, what this case is all about. That your lordship will be taken through a series of witnesses. Your lordship pointed out some 90 witnesses. They are there, my lord, simply to tell the narrative. But the narrative, my lord, is with great respect on the common cause facts before your lordship. I hope I've been of some assistance to the board.
Thank you very much, and thank you for this written exposition of the state's case. appreciate it. Thank you. It is accepted as Exhibit 6. We will now adjourn this court we will adjourn to Wednesday, 23 April, that is next week, 23 April at 9:30 in the morning in this same court, and the bail of the accused are extended to that day and time. The court will now adjourn, and may everybody have a pleasant and a joyful Easter weekend. Thank you.
Moet ek vir Harrington sê môreoggend 09:30? Okay.